All right, welcome back. Disability Law Show. We're back at it. John Scholes, Sivan Tumarkin here as well. Thanks for joining us for this half hour. Lots of stuff to teach you, so you'll want to stick around for the entire thing if you can. We'd appreciate it. Love to have you here. I'll give you the contact information right off the top, 1-855-821-5900. That's the phone number. Disabilityrights.ca is the website. If you put help at in front of that, that'll give you an email address, help@disabilityrights.ca. And I also want to mention mydisabilityquestions.com. That is a website built just for you. It is a place for you to ask your questions. If you're a little bashful, don't want to step up to the phone call yet, go to mydisabilityquestions.com. You can leave your questions there. Sivan and his team will answer them quite thoroughly. It's also a searchable database, which means if your question or something similar has been asked in the past, you can search for it, read the answer. Still not satisfied, leave your question there, and it will get answered. Sivan, we're ready to go at it here. I want to talk about a bunch of things today, including what constitutes bad faith conduct when it comes to your long-term disability insurer. That is on the show in just a little bit. But the week that was, pal, how are you?
I'm good, John. It's great to be here with you, with the audience. And, you know, just off the bat, I want to make sure people know and understand, especially the new viewers, that I am a lawyer. I practice long-term disability, but my firm, which has offices in Ontario, British Columbia, and Alberta now, we help people all across these provinces with employment matters if they've been let go from their job. And you know, we also help them with their disability matters, and specifically short-term and long-term disability. So let me tell you about an interesting situation that happened this past week. I got a phone call from a 52-year-old woman who has 3 kids under 10, and she's from Calgary, and she suffers from a mental health illness. She was predisposed to it. She had issues from childhood, but things happened at work and you know, outside with her personal life in the last few years. And of course, COVID has not helped matters with isolation and everything else. Long story short, about a year ago, she went on leave. She went on short-term disability, and so she went through that, and then after that expired, she applied for long-term disability. She has a group benefits plan at work, and so she applied. She has a psychologist that is helping her, and she has a family doctor, and she also has a psychotherapist that she sees virtually now once a week. Now, she applied for long-term disability, and she was rejected by the insurer. She was denied on the basis of insufficient medical support confirming total disability from working. And she took that denial to her doctor, her psychologist, psychotherapist, and you know, they were surprised, first of all, that she was denied because she was approved initially for short-term disability. It was a different insurance company, but she was approved, and then she was denied by the insurance company. And so they wrote her some more reports, more helpful reports to support her being off work. And again, she went through the first level of appeal, which we're going to get into, John. And of course, as you can imagine, she was denied again. And after that denial, someone saw our show, a relative of hers, and told her to get in touch with me. And so I spoke with her and I explained that, you know, it's unfortunate that she went through the first round of appeal because, again, these appeals are useless. Right? I mean, these appeals are internal processes for the insurance company. They usually get you nowhere. I'm not going to say that they never work, just like I'm never going to say that you're never going to win the lottery if you play it. But the reality is these are internal processes. And what we do that's different when someone comes to us and we assess their claim and we confirm that they are in fact disabled from working is we start a legal process, a legal claim. And that does several things. Number one, it means that only we are allowed to then communicate with the insurance company. The insurance company communicates with us. In other words, the adjuster is no longer allowed, once we become involved, they're no longer allowed to communicate directly with the individual, the disabled person, our client. So we immediately shoulder that. We immediately take that off our client's place. They can focus on their health. That's number one. Number two, because we've initiated a legal process, now the insurance company internally shifts the claim to another department. It's no longer the previous adjuster that was managing the claim that's making decisions. It's a new adjuster, someone who typically is in charge of resolving these kinds of legal claims. And, you know, and the third thing that happens is that you typically have a defense lawyer assigned. And we want the defense lawyer to be assigned by the insurance company to defend the legal claim that we are bringing, because that is our leverage with the insurance company. We need to get our legal claim in the hands of someone who understands the legalities on behalf of the insurance company, somebody who understands that if we were to go all the way all the way in front of a judge would most likely bring the hammer down on the insurance company. And I want to make that clear. Rarely do these cases actually end up in court. Okay? This is not like TV. These cases almost never, ever go to court. It's just simply too expensive for insurance companies to litigate these kinds of claims. And so when we start the legal process, typically within a matter of weeks or months, we resolve these claims by forcing insurers to come to the table and pay our clients what they're owed. And that's what I explained to this lady, and I expect that within a matter of weeks, maybe months, but probably weeks, we'll be able to resolve her claim. And again, this is a case where had she come to me before she had previously appealed the denial, I probably would have resolved the claim for her already. But the good thing is she reached out to me, I spoke with her, reviewed everything, we'll be able to help her. Just like John, we help tons and tons of people across all of Ontario, BC, and now Alberta.
There's a reason why you mentioned the fact that the firm does both disability law and employment law, Sivan, off the top, and that is there's a lot of interplays, you call it, between the two. And in that regard, there's another really cool tool called pocketemploymentlawyer.ca. You can go there. I mean, employment's in the title, but there is a pretty robust section on disability law within the pocketemploymentlawyer.ca website. Tell me about it.
So first of all, I'll give credit where credit is due. My partner, Samfiru, who does the employment law show, he's the employment guru, it's his brainchild. He came up with it. Essentially, the idea behind it is very simple. Lawyers traditionally have charged hundreds, if not thousands of dollars for the advice that this free tool now provides individuals all across the country, and specifically, again, those 3 provinces where we can help people. And you know, what this is essentially is if you experience an employment law issue, you've been let go from your job, you're being harassed at work, there's something that is going on you need answers to, and you don't want to necessarily contact an employment lawyer or a disability lawyer, right? You may have a disability issue with your insurance company, or you may have been injured and now you have difficulty working, and again, you're having problems with your employer or with your insurance company. The Pocket Employment Lawyer is where you go to. It's a free online tool, and essentially it's a series of questions with menus, and it's going to lead you to the right result. And at the end of the day, if you want to chat with us after getting the information you need from this online tool, well then we're more than happy to speak with you, but at least you have something you can go to get accurate information, not only about employment law matters, but also about long-term disability matters. And again, John, this is something that is completely new in the field. He came up with the idea, we worked on it together for months and months, designed it, and it's just free for the public. Again, just giving information to people. Knowledge is power, and that's the goal for this online website.
Again, pocketemploymentlawyer.ca is where you find that. It's free and anonymous, as Sivan says, but there is a contact button at the top right if you want to carry forth and talk to Sivan or Lior at that point. Email address, again, help@disabilityrights.ca. Let's get to the first email for the day here, Sivan. Comes from Leonard. Leonard says, my wife suffers from a combination of mood disorder and depression. She's been on LTD for just over a year and just received a letter from her adjuster saying at the 2-year mark, they think that she will be able to go back to a different kind of job. Can we do anything about this if she's in no state to return?
This is something that happens, unfortunately, John, quite often, this 2-year mark. So let me break this down again for new viewers to the show. With long-term disability, the majority of policies that people have, either through work or if they purchased a policy privately, contains provisions and sets out criteria for when you're entitled to get long-term disability payments. And typically, for the first 2 years, for getting LTD, for the first 2 years, you have to demonstrate that you cannot do your own occupation. Okay, John? So if you're a barista at a Starbucks, or if you're a TV show host, or you're a lawyer, or whatever it is, the first 2 years you have to demonstrate through the help of your doctors or whoever is that's helping you, psychologist, psychiatrist, whoever, that you cannot do the essential tasks of your own occupation. Beyond the 2-year mark, the test changes. Now the test becomes a little bit harder to meet. The test is no longer can you do your own occupation, but rather can you do any occupation for which you are suited for by training, education, or experience. So again, it's not any occupation, it's any occupation for which you're suited for. And typically we look at commensurate income, okay? If at the 2-year mark, you can do a job or an occupation that can pay you 60, 65% of your pre-disability income, well, then the insurance company is most likely going to say you don't qualify beyond the 2-year mark for LTD. However, unfortunately, as in this case here, John, insurance companies typically just blindly say, we don't think that you're going to qualify at the 2-year mark. And they sometimes say that months and months, if not even a year or more than a year, in advance of that 2-year mark. How do they know that? How do they don't have a crystal ball. They certainly don't know more than your doctors who have been treating you do. Well, you have to understand the way insurance companies operate. Leonard, insurance companies operate in a very simple way. They're trying to make profit. That is really the motivation, the goal, and the overall objective. And the way they do that is by not paying legitimate claims if they can help it, if they can do that, or if they have to pay as little as possible. Now, I'm telling you this from my own experience, having seen insurance companies, tell tons of people out there that they will not qualify or do not qualify beyond the 2-year mark. And when I speak with individuals, doctors and therapists, I am told something completely different. The person cannot do any other job or any other occupation. I don't know what the diagnosis is going to be in a year. I have no idea what the prognosis is. So again, you have insurance companies, John, who tell people, we don't think you're going to qualify beyond the 2-year mark, when really there is nothing to substantiate that. And so what I tell people is, contact me when that happens, because we can go after the insurer. We can pressure the insurance company either to reverse course, or we can warn them that if they unjustly cut off the claim, if they stop payments at the 2-year mark when the person is now ready to go back to any occupation for which they're suited for, we can take legal action against them. And it's happened quite a few times before, John, that we've gotten involved and the insurance companies have backed off. And when they have not backed off, well, guess what? We went after them and we forced them to pay our clients what they're owed.
We'll take a short pause, pal, but when we come back a little later on in the show, what constitutes bad faith by your LTD insurer? That is on the way. In the meantime, reach out, 1-855-821-5900, and that email address we use is help@disabilityrights.ca. It's a disability law show. Stick around. We're coming right back.
People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Disability Law Show. John Scholes, Sivan Tumarkin this week handling the show. I mentioned it before the break, Sivan, so we want to get right into this and what constitutes bad faith by your long-term disability insurer. By the way, to reach out, help@disabilityrights.ca. We'll get to another email in just a bit. And the phone number anytime, 1-855-821-5900. So number one is this. I know you'll get to these in depth. Ignoring pertinent medical evidence that clearly shows you are disabled. How about that one for number one?
John, not a week goes by when I don't get a phone call or an email from someone who tells me I've been denied long-term disability, I've been cut off long-term disability, or my adjuster is just not listening. They're not reading what my doctors are giving them. Well, listen, you need to understand something here. A lot of these adjusters, they have a certain motivation, and the motivation is to save money for their overlords, right? For the managers and supervisors, the insurance company in general. Now, I don't want to paint everyone with the same brush, because some of these adjusters I actually know, and some of them are good people. But here's the thing. Insurance companies have an obligation, and it's a sacred obligation under the law, to treat their insureds in good faith. It's a fiduciary obligation. Okay, courts have talked about this in various cases that have gone before judges before. Insurance companies cannot and are not allowed to ignore pertinent medical information. But what I see quite often, unfortunately, is the insurance company ignoring ignoring what family doctors are saying, what specialists are saying, what psychologists are saying, to the detriment of the individual. And what happens is that people don't understand. They don't understand how it is that the adjusters are ignoring this information. And so what I tell them, if you're cut off or you're denied long-term disability and you come to me and it's as clear as day that the insurance company simply turned a blind eye to information that was right there in front of them, and despite that, cut you off or denied your claim, well, guess what? We're not going to go after them just for what they owe you under the policy. We're going to go after them for what's called punitive damages, which courts in Canada have recognized as punishment against insurance companies for conduct that they deem to be high-handed. And there is precedent for this. We have cases all across the country where insurance companies who have acted in a very bad way, I'm talking about really, really bad, okay? When something is absolutely crystal clear, you know, it's white and they say it's black or vice versa, where insurance companies have had to pay above and beyond what the policy provides. Punitive damages, aggravated damages, these are extra contractual damages. That's bad faith damages. It's the courts basically saying to the insurance company, you acted in bad faith, you're going to be punished for that, you're going to have to pay this individual above and beyond the policy. So that's what that means. And unfortunately, I see this time and time again. And, you know, oftentimes when we're dealing with these kinds of claims and we're dealing with the defense lawyer, I can tell you, John, without giving out names, confidentiality reasons, when we resolve these claims, I've had situations where defense lawyers have come to me afterwards and said, we have no idea what the adjuster was thinking, you know, when they ignored this medical information. So again, if you are aware that this is happening to you, don't take it. Contact us. At least we can tell you what you can do. It'll cost you nothing to get this information. We can advise you on your next steps, and then you can decide how you want to deal with it. But again, knowledge is power. Okay? Don't get bullied by the insurance company, and certainly don't back down when they're trampling your rights.
We're checking off a few boxes. What constitutes bad faith by your long-term disability insurer? The next one, Sivan, is this: disregarding the financial and emotional hardship you will endure.
I've had situations where people have lost homes, they've lost cars, they've had to sell memorabilia. Again, when we're seeing cases where it is just completely clear that the insurance company is ignoring, you know, the situation, the reality. Okay, they're living in an alternate universe, and that's causing you tremendous financial hardship. And by the way, John, I've seen a situation once, actually not that far back, where it led to a divorce. And there was then subsequently a custody battle. Everything just because the insurance company did not do what they were supposed to under the policy, when it was clear as day that the person was disabled. Again, to me, those kinds of cases, they cry out for punishment against the insurance companies, to punish them for their conduct, for making these individuals' lives miserable. Because remember, you're dealing with disabled people. You're dealing with people who are suffering from a severe injury or an illness or a combination of both. And on top of everything they're going through, they have to deal with the insurance company that's not doing what it's supposed to do under the policy after they've collected potentially years' worth of premiums. That's not right. And there is a way to force them to pay, not only, again, what's under the policy, but above and beyond that.
We're talking about what constitutes bad faith by your long-term disability insurer. If any of these sound familiar to yourself or somebody you know is going through this, don't hesitate to reach out to Sivan and his crew, of course. This one, terminating your benefits before receiving an update from their IME doctor.
Let's clarify this. Yep. This is really something. This does not happen that often in my experience, but it has happened. So insurance companies, John, we've talked about this before, are entitled, you know, when you are on long-term disability, they're entitled to have you seen by one of their medical examiners. Okay, let's say you have a psychiatric issue and they want you to be seen for an assessment with one of their psychiatrists. You have to attend these assessments. I mean, now with COVID, it's probably going to be virtual, but be that as it may, you have to attend. Sometimes it's a chronic pain doctor. Sometimes it's a physiotherapist, whatever. They're entitled to have you seen by one of those individuals to assess whether or not you are as disabled as you say you are, that you are unable to work, etc. But what happens when they insist on you attending one of those assessments, and yet they don't wait to get the report from their assessor? They cut you off prematurely before they even get those results. So they don't have anything to hang their hat on. And usually when that happens, I can tell you, John, it's because the adjuster is just rushing it, right? It's just clear. It's just clear that the adjuster was intending on cutting a person off or denying their long-term disability. And this whole idea of having this person seen by an assessor was just, there was no legitimacy to it. They did that just to check box, to check the box. And I've seen this time and time again happen when an insurance company, they jump the gun. Again, in this instance, that's more rare, but I've seen them many times jump the gun. For example, they'll ask you to provide a report from your doctor. They won't wait for it. They'll cut you off before you're able to get that report from your doctor. But when they have you seen by one of their doctors, right, and they don't wait to get the report from that doctor, to me, that cries foul. I mean, that's just horrible. It just tells me that the insurance company is not interested in the truth, which means, again, that they are exposing themselves for a claim for extra contractual damages. And I would go after them for a lot more money than what just the policy says. I would go for, for punitive damages, aggravated and general damages for your pain and suffering for what you've had to go through.
If they make that choice before they get the information back, though I don't want to go down too much of a legal rabbit hole, but would that be anticipatory breach or no?
So anticipatory breach is a principle in law that we see in disability type claims, especially in my practice, where the insurance company says ahead of time, they're saying, look, we are going to cut you off in 3 months, in 6 months. So in other words, they're not saying we're cutting you off now, and so that would be an immediate breach of contract. They are saying we're going to do that at some point in the future, and the basis for that is simply illegitimate. It's wrong. In other words, that's our position. We say, no, insurance company, you are incorrect. So circling back to what we talked about at the beginning, John, where the insurance company says, we think that a year from now you will not qualify for LTD beyond the 2-year mark, and yet the treating doctors are saying, well, we don't know that. We have to assess. To me, that would be anticipatory breach. The insurance company is breaching their obligations under the policy now when they have no grounds to tell you that your benefits will stop in a year. Right? It's premature. And again, they jump the gun. This is the kind of stuff that we see all the time. Insurance companies jump. They jump the queue. They want to get you off claim, shake you off claim. Why? Because every month that they pay you is a month that they're paying you, in their minds, too much. They're trying to shake you off claim. So again, if you're in that situation or you know someone in that situation, please tell them to contact us or go to our website, get the information you need to understand what your options are, because you do have options.
I want to get to these last two before we take a quick break. Sivan, another one is this, talking about bad faith with your LTD insurer and making lowball settlement offers or pressuring you to settle without the benefit of seeking legal advice.
We see that less and less now. I think insurance companies have been burnt quite a few times where they have been told by judges you can't do that.
Right.
And look, an insurance company may approach you, especially when you have a severe injury or illness, and they understand they're going to be paying you a ton of money into the future, and they're trying to offer you a fraction of that amount and then pressure you and say, if you don't accept that now, we may cut you off in 3 months. We may cut you off in a year. Well, guess what? They can't do that. I mean, they can approach you about a lump sum. You better be very careful in accepting that lump sum, right? They're not offering that out of the goodness of their heart. Usually they offer you a mere fraction of what they know they're going to have to pay you in the long term. But when they tell you, accept it, or you should really accept it, but don't bother talking to a lawyer, to me, that is a huge breach of their obligations under the law, their fiduciary obligations, because essentially what they're telling you is, don't examine your rights, don't do your homework, don't do your due diligence, trust us. John, I would love to take a poll for our audience. How many people trust what insurance companies tell them, right? I mean, you got to be careful.
Yeah.
And if you don't trust me, then by all means, do what you think is right. But I'm telling you, this is anecdotal, but this is something that many lawyers who practice in this area on behalf of individuals who fight insurance companies day in and day out, they see this all the time. Do not take what your insurance company says at face value, because they have one interest only, and it's not you, it's their bottom line.
Last one for this segment, Sivan, is this, denying benefits for an unreasonable amount of time. That's bad faith right there.
Yeah, absolutely. And again, that's formed the basis of bad faith. I got people calling me saying, I was approved 3 months ago, where's my check? And they follow up with these insurance companies. Listen, a lot of times it's a bureaucratic nightmare within the insurance company. These are large organizations, huge corporations, but there is no excuse once a person is approved for LTD not to get that check within a matter of weeks at the most. But in some instances, people, they apply and they just don't get any answers for months and months at a time. So again, you gotta press the insurance company, or if you're not getting anywhere, reach out to us. Let us help you, because we deal with these kinds of cases and we resolve these kind of situations each and every day in our office.
We mentioned the website earlier, mydisabilityquestions.com. That is where we are going right after a short break, so we'll do that and come back to it. 1-855-821-5900 is the number to reach out, and we'll be right back to it. Disability Law Show. Stick around.
People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Disability Law Show. Time ticking away, Savannah. I want to get to this one final letter here from mydisabilityquestions.com. Comes from Brendan this time. He says, I've been off work on LTD due to traumatic brain injury. Last month, my insurer sent me to get assessed by a physiotherapist and occupational therapist. After the sessions, my symptoms grew worse. I was told that after 8 weeks or so, I should be ready to start a gradual return to work. I asked my family doctor, and he thought I had to do what my insurer said. Can my insurance force me to go to physio/occupational therapy?
No, absolutely not. They cannot force you. And in fact, your doctor is actually wrong. You don't have to do what your insurance company is saying. You have to, or what you should do, is follow what the doctor is saying. Trust whatever your doctor is recommending. And listen, if your doctor is saying you need physio and you need occupational therapy, then follow those treatments. Because if you don't follow those treatments, then the insurance company will cite you for non-compliance, and on that basis, they'll cut you off. But John, I tell people all the time, listen, maybe the insurance company's assessors have some recommendations which are helpful, which is great. But, talk to your doctors about this. This is the key thing. Your treating doctors have your best interests at heart, or at least they should, much more certainly than the insurance company. And if the insurance company's assessors say do X and Y, again, check with your doctors. And if your doctors agree, then do it. You don't have to do it with the individuals the insurance company has told you to do it with. You can get recommendations from your own doctors, and in fact, I recommend that you do that. But the key thing here is to always check with your doctor, to follow your doctor's recommendations, and if something's not working, have a chat with your doctor and explain what's not working, and then, figure out something else that works. But again, you want to get better, follow whatever your doctor is saying, and do not do something the insurance company is telling you to do if it's making you feel worse.
MyDisabilityQuestions.com, that is where you want to go. We mentioned that. It is a searchable database for questions just like Brandon's, if you haven't used that before. Leave your question there. Sivan, James, Tamara, a member of their outstanding team, will look at it and answer back. Searchable database. It may have been asked before, so make sure you do that first. The phone number we throw out every time, 1-855-821-5900. Use that. And email, which we got to today as well. There's it's endless ways to contact Savannah and those guys. It's help@disabilityrights.ca. Again, help@disabilityrights.ca. That's it for today. Thanks for hanging out for the entire 30 minutes, and we'll catch you next time. Disability Law Show.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca.